Hola, buenas tardes.
Buenas tardes, señor perito. Le agradecería manifestar ante la Corte su nombre.
Paolo, Carozza.
Muchas gracias. Nacionalidad y lugar de residencia.
Nacionalidad estadounidense y también residencia en Estados Unidos.
Muchas gracias. El experto deberá limitarse a contestar clara y precisamente las preguntas que se le formulen, ajustándose a los hechos o circunstancias que le consten en relación con su experiencia. Se le informa que fue citado por la Corte para declarar sobre la relevancia del principio de dignidad humana y la protección requerida por el derecho internacional de los derechos humanos a todos los seres humanos sin distinción por su desarrollo, capacidades, sexo o condición. Asimismo, se referirá al alcance de las obligaciones internacionales derivadas del derecho internacional de los derechos humanos y el margen con el que cuentan los Estados para adoptar legislación que proteja a los seres humanos que estén por nacer. Se le informa que, de acuerdo con el artículo 53 del reglamento de la Corte, los Estados no podrán enjuiciar a las presuntas víctimas, a los testigos y a los peritos, a sus representantes o asesores legales, ni ejercer represalias contra ellos o sus familiares, a causa de sus declaraciones, dictámenes rendidos o su defensa legal ante la Corte. A continuación, señor perito, el presidente le tomará el juramento de rigor. Todos de pie, por favor.
Señor perito, ¿jura o declara solemnemente que ejercerá sus funciones de perito con todo honor y con toda conciencia?
Lo juro.
Muchas gracias. Sírvase tomar asiento. El señor perito tiene la posibilidad de presentar, antes de ser interrogado por las partes, una exposición libre de máximo 10 minutos referente al objeto de su pericia. Adelante.
Gracias, señor presidente y honorables jueces de la Corte. Es un gran honor estar aquí nuevamente antes de esta Corte, aunque es la primera vez que estoy aquí como perito y no como comisionado. Mis comentarios iniciales quisiera simplemente subrayar algunos puntos claves de mi informe por escrito, pero con su permiso quisiera seguir en inglés para que pueda ser lo más preciso posible con mis argumentos. Gracias. Your Excellencies, it is very appropriate that we begin here with the central importance of the principle of human dignity. International human rights law confirms without exception that the recognition and protection of the equal dignity of every human being is the cornerstone of all human rights. As the guarantor of human dignity in the inter-American system, this court has affirmed many times that the equal rights of all human beings flow from their equal dignity. Without this stable ground, human rights would become illusory and arbitrary, belonging only to those human beings whose value is already acknowledged, and not to those whose value is ignored and rejected by those who have power. The status and principle on which all international human rights law rests can be understood to have four essential qualities. First of all, human dignity is universal. It belongs to every human being solely by virtue of being biologically and genetically a member of the human species. This is an objective and scientific basis, not one based on any ideological or philosophical or religious category of who counts fully as a human being. For example, it's not based on the theory that the worth of a human being depends on a sufficient rationality or consciousness or autonomy or on a moment of ensoulment. Secondly, human dignity is equal. The court has affirmed many times in its seminal judgments on equality the intimate relationship between human dignity and the Jus Cogens principle of non-discrimination. Dignity does not come in degrees, with some human beings being more dignified than others. Nothing could be more antithetical to the very idea of human rights. Thirdly, human dignity is inherent. It is not conferred by any power or by the state or by the law, not by majoritarian social conventions or by the will and choice of any other person. And for the same reason, fourth, human dignity is inalienable. No one can lose or be stripped of her inherent human dignity by anyone or anything else. Therefore, no condition of weakness, vulnerability, illness, disability, or incapacity, or failure to be recognized as a person in the law can deprive a human being of their essential dignity. Now, these four dimensions of dignity have clear implications for the rights at stake in this case. They entail that a mother and her child, born or unborn, including both Beatriz and her daughter, are equal bearers of dignity. That cannot change simply because one of them is ill or disabled, or less developed or more vulnerable, any more than it could change because one human being is of a different gender or race or sexual orientation or social class than another. That equal human dignity in turn requires states to respect and protect the equal human rights of every human being. And the right to life, as noted frequently in this court's jurisprudence, is the first of those rights, because without it, all other rights are null and meaningless. The text of Article 4.1 of the Convention places it beyond any reasonable dispute that in the inter-American human rights system, human beings are holders of the right to life from the moment of conception, even before birth. The explicitness of that text makes inter-American human rights law distinctive. In accordance with the international law of treaties, that intentionally distinctive language must be interpreted in a way that will give it meaning and effet utile. In addition, this court has repeatedly and consistently held, first of all, that the right to life must be interpreted in an extensive way, allowing for no restrictive interpretations, in accordance with the pro persona principle. It is held that their state has broad range of duties to protect the right to life, including against violence by other private parties. And it is held that there may never be any discrimination among the subjects of the right to life. In sum, under the American Convention, as interpreted by this court, both a pregnant woman and her child in utero are entitled to the affirmative, simultaneous, and equal protection of the right to life by the state. Now, Article 4.1 does also specify that that right must be protected in general from the moment of conception. How should we understand that expression? The expression cannot be understood to mean partially, or incrementally, or gradually, or subject to exceptions, or conditional on the will and choice of another person. That would effectively empty the right of any content, exactly the opposite of giving it effet utile. It would contradict the object and purpose of both Article 4 and of the treaty as a whole, and it is manifestly incompatible with the principle of non-discrimination. In short, it would constitute, I believe, the very definition of arbitrariness. Now, instead, more consistently with the object and purpose of the Convention and with its travaux préparatoires, I think we must understand the expression in general as intending to accord an important degree of discretion to states to determine the exact forms and methods of exercising their duties to protect life prior to birth. This includes discretion regarding whether and in what circumstances to employ criminal penalties, or instead to use alternative means to protect the human lives of both mother and child that are present. In other circumstances, this court has always required criminal penalties in the protection of the right to life. To my knowledge, without exception. It is the paradigmatic necessary method. However, in this case, Article 4.1's expression in general does, I believe, modify that obligation to impose criminal penalties. And it allows states, permissively but not mandatorily, to employ other measures, so long as they are, in general, oriented towards protecting human life. But in whatever way the state may specify and carry out its duties to protect the right to life under the Convention, those duties do pertain simultaneously to both the mother and the child from the moment of conception. I believe a little reflection will show us that any other conclusion will only result in deep and unsustainable contradictions in this court's jurisprudence and in the law of the inter-American system. For example, it's hard to imagine that this court would ever be willing to affirm that among human beings who hold the right to life, the state may be willing to choose to protect some more than others, or to prefer the life of one person over the life of another, or to declare that a life plan or a dignified life of someone who, for example, has a mental disability or is in the final stages of her life is of less importance than that of any other human being. Nor could it be possible for this court to set aside its commitment to the jus cogens principle of non-discrimination in order to accept arbitrary differentiations in the protection of human dignity and human life, being based on a human being's age or stage of life or illness or mental capacity. The court cannot uniquely restrict its extensive interpretation of the right to life with respect to prenatal human life without introducing de facto exceptions to the pro persona principle that would result in human rights law becoming pro persona for some, but anti persona for others. And finally, this court has always laudably been the champion of the human rights of the most vulnerable and marginalized members of our societies. How could it accept that some human beings' vulnerabilities could be a justification for granting less protection to their rights? Each of these positions contradicts in very fundamental ways the most cherished building blocks of this court's corpus juris of human rights over the past 40 years. Now, there is an alternative. The alternative is to affirm unequivocally that the duty of states is to protect equally and simultaneously the human rights of both women and children, born and unborn. That is the path that is the most coherent with the promise of universal human rights. It is the most consistent with the explicit and distinctive text and requirements of the American Convention. And it is the only approach that takes seriously the obligations of non-discrimination, the expansive pro persona interpretation of the right to life, the duties of states with respect to those rights, and the interdependence and indivisibility of all human rights. Such a judgment by this court would be bold and transformative, it is true. It would set our societies on a radically new path in which the promise of universal human rights would finally be capable of overcoming the polarizing divisions that have plagued this area of law for so long. Thank you very much.
Muchas gracias, señor perito. Daré ahora la palabra a la representación del Estado para que proceda con el interrogatorio. Indicar, por favor, quién se va a hacer cargo del mismo. Y procede. Adelante.
Señor presidente, gracias. Yo haré las preguntas al perito. Profesor, ¿cómo está? Muchas gracias por estar acá. ¿Usted podría indicarle brevemente a la Corte algunos aspectos relevantes de su experiencia académica y profesional?
Yes, of course. I've been a scholar of human rights in both public international law and comparative constitutional law for the last 30 years. In that time, I've published many books and articles on various aspects of human rights, including the leading textbook on the protection of human rights in regional systems. The last 27 years of that time, I've been a professor of law and of political science at the University of Notre Dame in Indiana in the United States, where I've also directed the human rights program, directed the doctoral program in international human rights law, and was the director of the Kellogg Institute for International Studies. I have also taught at other universities as a visiting basis from time to time in the United States, including Harvard University, universities throughout Western Europe, and universities in Latin America and in Africa. I have also had the privilege of being able to serve on important human rights bodies outside of the academic context. I was a member of the Commission, the Inter-American Commission on Human Rights, and its president in 2008 and 2009. And I'm currently a member of the European Commission for Democracy Through Law, better known as the Venice Commission, and was elected to be part of the executive leadership of that commission as well.
Gracias. Profesor, en su peritaje escrito usted ha señalado que existe una presunción por defecto de que el derecho penal es el medio más apropiado para garantizar el derecho a la vida de todos los seres humanos por nacer. ¿Podría profundizarle a la Corte un poco a qué se refiere esta afirmación?
Yes, as I indicated in my opening remarks, I am aware of no case involving violations of the right to life in which this court has ever refrained from obliging the state to investigate and punish with criminal laws the perpetrators of the violence. It's most obvious, of course, in cases of gross violations of human rights, such as the series of amnesty cases where criminal law is required. But it's present in a variety of other cases involving the right to life as well, including cases, for example, touching upon medical malpractice.
En el caso Artavia Murillo contra Costa Rica, esta corte afirmó que la vida debería protegerse de forma incremental. ¿Cuál es su opinión sobre este fallo en relación con el concepto de dignidad humana que ha abordado en su intervención?
Well, I will be very frank and not try to hide things. As I said in my opening remarks and said very clearly in my written report as well, I believe that incremental or gradual is nothing less than arbitrary. There are no clear and objective lines that protect the right to life, and it ends up emptying the right of any content in practice. And therefore, I believe that part of the Artavia decision simply must be regarded as erroneous. It is inconsistent with every other decision that I know of on the right to life in this court, in not granting an expansive interpretation of that right and in not granting affirmative duties of the state with respect to that right. Now, fortunately, I think that it is also the case that statement interpreting the words in general in the Artavia decision were in fact not necessary to the outcome of the case. The court had already decided that case on the basis of a conclusion that an unimplanted human embryo is not yet at the stage of conception and therefore not a holder of the right to life under Article 4.1. So everything that it says after that is just obiter dicta and not necessary to the holding of the case. So I do believe that the court can correct what I regard as a grave error in Artavia without actually affecting the important result of that case.
¿Qué opinión tiene usted sobre las recomendaciones de comités convencionales de Naciones Unidas en relación con la despenalización del aborto en ciertas circunstancias?
Well, I mean, I think importantly, the first starting point needs to be the treaty basis that we're working on. The American Convention on Human Rights, as I said, is distinctive. It's different from all the treaties that those bodies are interpreting in explicitly calling for protection of the right to life prior to birth. And therefore, there's a problem of comparability already from the start. Now, that said, I think we also have to look carefully at what those different committees and other bodies have in fact said. Sometimes cases such as KL versus Peru at the Human Rights Committee are sometimes understood as fostering a development of a right to abortion. I don't think they are properly read that way. That case and comparable cases in other systems like the Taisiak case in the European system or even the friendly settlement in the Paulina case in the inter-American system, all those cases are based on the fact that the domestic law has already provided for certain legal applicability, legal access to abortion. And the issue in that case was the arbitrary interference of someone with what was guaranteed to them under domestic law. So we can set those aside as well, I think, at least with regard to your question. So then that leaves recommendations which we know are there that also say, tend towards saying, at least in some limited ways, abortion should be recognized at an international level as well. What do we make of those? First of all, I think we should remember that they're recommendations. They're not holdings of a court, and that difference does matter. There's a reason those treaties were structured in such a way as to not provide them with something like the Inter-American Court of Human Rights that has definitive and binding interpretive authority. And so to treat recommendations the same way that we treat judgments, I think is not only faithful to international law, but is not helpful to affirming and maintaining the authority of those bodies that actually do have jurisdictional authority, like this one. And so what do we need to do? We need to, I believe, look at those recommendations in good faith, one by one, take them seriously and ask, do they have merit? They're not binding simply by the say-so of the committee. They may be persuasive based on the merit of the position. In these cases, I think there are good reasons to think that the positions are not persuasive, in part because the very treaties that they're purporting to interpret say nothing about about abortion, and on the contrary, provide very expansive statements about the right to life. In the case of the Convention on the Rights of the Child, even affirming in its introduction, in its preamble, that it is intended to be protecting human children prior to birth as well as afterwards. And the second reason to be doubtful of their persuasiveness is that we can find no examples, not even in soft law, of ways in which the community of nations has endorsed these principles and regarded them as binding. In fact, the closest authority we have to a comprehensive statement of the community of nations, which was issued at the Cairo Conference on Population and Development, says very explicitly that they do not recognize an international right to abortion.
Profesor, ¿cómo compatibilizar estas posturas que usted ha señalado con el principio de interpretación evolutiva de los tratados?
Well, thank you. I mean, clearly, I would not want to be understood to say that a dynamic or evolving interpretation is not appropriate. It's been an important part of this court's and jurisprudence since the beginning, and has a significant value. But it is important to remember that the evolving or dynamic interpretation that a court engages in is something that is supplemental to and must be consistent with the treaty. It starts from, first of all, what are we interpreting? It's not interpreting an empty space or air. And it needs to be consistent with that, and therefore it cannot contradict the treaty. This court has said as much in, if nowhere else, at least I know of one example in its advisory opinion on juridical personhood, where it says very clearly the treaty restricts the extent to which we can engage in interpretation that is not faithful to the text itself.
Profesor, en el caso concreto de Beatriz, la comisión en su informe de fondo señaló que la inviabilidad de la vida del feto rompe la relación de medio a fin entre la criminalización y la finalidad que supuestamente persigue, ya que el interés protegido, vida del feto, indefectiblemente no podrá materializarse en la realidad pese a la prohibición penal de la conducta. ¿Qué opina usted de estas afirmaciones en relación con el principio de dignidad humana?
Well, I think I'd make two observations, but they're interrelated. The first one is that the Commission, in its merits report in the matter, has failed to recognize that Article 4.1 and the right to life is in fact engaged and present on behalf of the unborn human being. It refers to a state's interest in potential life. Now, a state's interest in potential life is a very different thing from a right to life under the Convention. So framed in that way, it makes the calculus quite different, right? A human right on one side, a state interest in potential life on the other side. So if we first recognize that there is a human life present, then it changes the calculus quite a bit, I think, or it ought to. So now secondly, the second step then would be to take then more explicitly what you have asked me. Does that calculus change just because one of the human beings in it is disabled, even perhaps disabled to the point of not being able to survive outside the womb for more than a short time? And I think the answer must be no. The answer must be no. I think to illustrate why, perhaps the easiest way to do so is to imagine someone who is in the terminal stages of life and has only days or hours or even minutes to live. We would never say that such a person has lost the right to life or human dignity, and that in those final moments, because that life is no longer viable, that it could be killed or tortured or poisoned or dismembered. And so equally, I think the same is true of a disabled child prior to birth in terms of non-discrimination, or to a child who is already born, but in conditions of incapacity.
Profesor, el profesor Cristian Curtis señaló en un post el día de ayer, refiriéndose al caso de hoy ante la Corte, que más allá de discutir si puede considerarse que un feto es una persona, es evidente que el modelo social de discapacidad, incluido en la Convención de Personas con Discapacidad, no se limita a la existencia de deficiencias, sino que requiere interacción con un medio social en el que existen barreras de participación plena y efectiva. Por definición, el feto no tiene ninguna interacción social, por lo que difícilmente puede aplicársele una definición social de discapacidad. ¿Qué opina usted de esta afirmación?
Well, first of all, I think just as a factual matter, it is a great reductive position because it seems to me clearly the case that even an unborn child is involved in society in important ways, receives medical care, interacts in various ways with the environment. Now, I'm not competent to testify to the fetal development of human life, but that seems to me self-evident. And moreover, that affirmation is consistent with what the Committee on the Convention of the Rights of the Child, the Committee on the Rights of Persons with Disabilities has itself affirmed, taking the position explicitly that a selective abortion of human fetuses with disabilities, even when those disabilities are going to be fatal to the child, constitutes discrimination under the treaty. So clearly rejecting that position, and it's reasonable that the committee would reject that position because conceptually underneath it, what is it saying? It's saying that a person's dignity and rights depend on whether they're accepted by society. I mean, that's exactly the opposite of what we're trying to affirm when we affirm human rights, I believe.
Profesor, ¿qué opina usted de que se considere que las leyes que prohíben el aborto son maternidad forzada y por tanto tratos crueles, inhumanos o tortura, como algunas veces lo ha mencionado el relator para la tortura?
I don't believe there is any legitimate foundation in international law to conclude that restrictions on abortion are per se, or could be deemed to be per se, violations of the right to be free from torture. For starters, I think the juridical elements are simply absent. The intentionality, the illicit aim, and so forth of those right violations are not present here. In addition, a conclusion about those violations, I think, needs to be done necessarily at the concrete level of facts of a case, and not in the abstract. So, for example, even in the TCAC versus Poland case at the European Court of Human Rights, the court found a violation of the treaty insofar as the state prevented the petitioner from accessing legal rights to abortion under Polish law, but then went on to look at the specific facts of the case to say and conclude that it did not violate Article 3 of that treaty, or constitute torture, in other words. So I know that the special rapporteurs, as you said, at least one, perhaps two, have made very broad and generic allegations to this regard. I don't think that they really have any basis in international law, at least of all in any way that has been supported by the states.
Señor presidente, dado que ayer acordamos que debido a la traducción podíamos tener flexibilidad, ¿puedo hacer una última pregunta? Gracias, señor presidente. Profesor, los representantes de las víctimas en este caso han mencionado recientemente, refiriéndose al caso que está ante la Corte, que, abro comillas, el esfuerzo de salvar las dos vidas debe hacerse siempre y cuando eso sea lo que quiere la mujer, cierro comillas. La profesora Isabel Cristina Jaramillo, perito ante la comisión, también ha argumentado, y lo reitero hoy, que no se puede dar derechos al no nacido en contra de la voluntad de la mujer embarazada. ¿Usted considera que estas afirmaciones son compatibles con la Convención Americana sobre Derechos Humanos?
To be quite blunt, I have a hard time seeing how that position is anything other than saying that the rights of a human being are conditional on whether they are accepted by some other person, and in particular by a person who has a very extensive power and control over that life. And I don't believe that is compatible really with the basic foundational principles of human rights at all, to say that my life and my rights are dependent on somebody else's choice or will.
Gracias, profesor. El Estado no tiene más preguntas. Gracias, presidente.
Muchas gracias al Estado y al perito. Daría ahora la palabra a la representación de las presuntas víctimas para que procedan con el interrogatorio, indicar quién se hará cargo del mismo y proceder.
Gracias, señor presidente. Quien le habla, Gisela de León, hará el interrogatorio. Hi, Dr. Carozza. Hi, Professor Carozza. Nice to see you again. I'm going to do the questions in Spanish. En primer lugar, quisiera preguntarle, de lo que entendí de su declaración, ¿usted considera que para que un órgano de protección de derechos humanos pueda pronunciarse sobre la convencionalidad del aborto, el tratado de que se trate tiene que reconocer específicamente, expresamente el derecho al aborto?
I think that's one important reason to doubt that the statements of the committees recognizing abortion are, in fact, valid and persuasive ones. It's one reason, it's not the only reason. I think, for example, if customary international law were to develop in the practice of states, having opinio juris and incorporating things, that might be a way also of adding a different argument as well. So that's one important data point, but it's not the only one.
Tomando eso en consideración, entonces, usted conoce la jurisprudencia de esta Corte en donde, por ejemplo, ha reconocido derechos como el derecho a la verdad, que no está expresamente reconocido en la Convención Americana, igual que el derecho a la identidad, que tampoco está reconocido en la Convención Americana expresamente. Quisiera conocer su opinión al respecto.
The court has done so in ways that build on the rights that are present and don't contradict the text of the treaty and the explicit rights that are already granted and recognized. So it's very different to say there's a right to truth than there is to say there's a right that's been granted by the convention and by the states, and we're going to take it away.
Entonces, ¿usted considera que siempre y cuando el tratado reconozca derechos que pueden ser afectados por un acto específico, el órgano de protección, en este caso la Corte Interamericana, puede pronunciarse al respecto?
I'm sorry, I didn't quite understand the first part of the question. Could you repeat it again?
Tomando en cuenta lo que usted acaba de decir, en el sentido de que la Corte ha construido la jurisprudencia sobre derecho a la verdad y sobre derecho a la identidad, que fueron los ejemplos que yo mencioné, sobre los derechos que están reconocidos en la Convención. La Corte sí puede pronunciarse siempre y cuando construya su jurisprudencia con base en esos derechos.
Well, I mean, I would say I wouldn't say always and in any case, right? In principle, yes, it could, as long as it's consistent with the other rights that are present, as long as it's consistent with the text. That's what the court has done. That's how it's approached the question of evolving interpretation. That's not to say necessarily that every such proposal to do so is necessarily well-reasoned, argued, juridically founded, and so forth, right? So to say that an evolving interpretation of the treaty is possible is very different from saying that this particular or that particular proposal to take an evolving interpretation is in fact correct or persuasive.
Entiendo. Entendemos que desde su punto de vista la protección del feto y del derecho a la vida es absoluto desde el momento de la concepción. Solamente quisiera que me confirmara esa afirmación.
It depends on what you mean by en absoluto, right? I think it does mean that there can never be an intentional and direct, purposeful taking of that life. But it is also the case that, as we know, and as has been, I imagine, in the discussion in this courtroom during this day, that there are situations where the life of the pregnant woman is also at stake. And so if what you mean is by absoluto is that there can be no termination of a pregnancy even when a woman's life is clearly directly at stake in that, then no, I would not agree with that.
Y tomando en cuenta lo que acaba de decir, si más allá de que la vida de la mujer está directamente en inminente peligro, si la salud de la mujer está en inminente peligro, en ese caso, ¿sería posible? O sea, ¿habría un derecho absoluto del feto o no?
Well, again, I think yes, there has to be, in the sense that one has to define absolute very carefully here, right? In the sense that it cannot be the intention and the goal and the aim of an intervention, even if it's called health, to kill the child, right? There can be health interventions that might pose risks to the child. And then very careful calculations and prudential judgments have to be made. How great is that risk? What is the potential benefit? In particular, is it necessary? Are there other ways of achieving the same goals? And one has to bear in mind that, health can come in degrees, but life cannot. So if one takes a life, it is the extinguishment of all rights, rendered null and meaningless, as this court has said.
Pero retomando lo que usted acaba de decir, tiene que existir una intención de acabar con la vida. O sea, si la intención es practicar un tratamiento que es necesario porque la vida o la salud de la madre está en riesgo, sí es permisible. No hay una intención de causar la muerte al feto.
I think there's an affirmative obligation always to attend to the health of the child as well as to the health of the mother. Right? And so there's always a question of how can you try to do both? How can you maximize both? Right? And it's not simply saying we're going to set aside one and pretend it's not there in order to maximize the health of the other. Right? So that will mean, for example, in some circumstances, undertaking a cesarean section, right, and a premature delivery in order to try to save the life of or the serious health implications of the mother, while still attending to the life of the child. It's very different from saying, for example, at the same stage of gestation, that what we're going to do is engage in a deliberate killing of the child, as opposed to. So to put it a different way, the question of a termination of pregnancy and the question of the killing of a human being are juridically distinct.
¿Y qué pasa cuando hay una colisión de derechos entre el derecho a la vida de la madre y del feto? ¿Cómo se resuelve esa colisión de derechos? Porque usted, quisiera volver a lo que usted decía en su presentación inicial. Decía que el Estado está en la obligación de proteger de manera igual a la madre y al feto. Y tomando en cuenta eso, existen casos, médicamente hablando, en donde puede haber una colisión de derechos entre el feto y la madre. ¿Cómo se resuelve esa colisión de derechos?
Yeah, certainly, again, even not as a medical expert, of course, I recognize that there are very complex medical decisions about what exactly are the risks that are being posed. It's always a certain prediction and assessment on both sides, what would be the consequences of a particular intervention. And so I think it is almost by definition impossible to answer that question in the abstract. And I believe that that is precisely why it was the case that in drafting Article 4.1, the states that did already incorporate some exceptions to criminal penalization of abortion did insist on maintaining language that would allow them to have a certain degree of discretion, precisely because there isn't a good word in English for idoneo, okay? It's not idoneo for international law at a generic level to be trying to resolve those conflicts. So as a general matter, those are exactly the kinds of things that are left to the discretion of the states to try to regulate in complex ways in their medical systems.
Pero entendiendo que usted no es un experto médico, sino un experto jurídico, ¿cuál es el camino jurídico para resolver ese conflicto de derechos?
Different states do it in different ways, right? And international law doesn't prescribe a single way to do it.
Quisiera preguntarle, frente a un caso en el que la vida de la madre está en riesgo por el embarazo, ¿la voluntad de la madre es en alguna medida relevante?
Well, in all medical interventions, informed consent is an important principle, right? A principle that is essential to human rights, to autonomy, to human dignity. And so in that sense, yes.
Muchas gracias.
Thank you.
Muchas gracias al señor perito y a la representación de las presuntas víctimas. Corresponde ahora preguntar a las señoras juezas y a los señores jueces de la Corte si desean formular alguna pregunta. Juez Rodrigo Mudrovich. ¿Va a realizar preguntas?
No, señor presidente.
Muchas gracias, señor juez. Jueza Verónica Gómez va a realizar preguntas.
Sí, señor presidente.
Adelante.
Profesor Carozza, un honor. Usted nos habló en su peritaje sobre el deber de protección igual y simultáneo. Usted dijo, duty to protect equally and simultaneously. ¿Cuál es el rol de la ciencia?
De las...
De la ciencia, science, en ese tipo de determinaciones. Yo sé que usted es un jurista, pero también hay un derecho a los beneficios de la ciencia. Y aquí, en el contexto de este caso, tenemos peritajes médicos, tenemos hechos que tienen que ver con una historia clínica, tanto de la madre como de su hija. Entonces, y también tenemos una situación de dependencia física y de esta situación de la encefalía, que una vez fuera de la madre había determinaciones de los médicos que hablan de una palabra que usted utilizó con prevención, que fue la de la no viabilidad, y que consideró que no podíamos considerarla en la ecuación de esta protección simultánea de los derechos. Pero ¿cómo hacemos valer lo que la ciencia nos dice sobre la condición médica de la madre y de la persona por nacer?
Well, exactly in the complex judgments that I was referring to in relationship to the last question from the petitioner's counsel, I think it's implicit in the answer, what I will make explicit now, which is, of course, scientific information, judgments, the best available. Of course, we all know that medical judgments can be uncertain as well, and are always based on limited information and limited understanding of what might happen. And so, but the best information that is available, of course, should feed into the judgment and help inform what treatment is going to be available. And what are the likely outcomes of those treatments. I would not say that it goes so far as to say what is the moral obligation to provide the best treatment available.
No me refería a eso, sino a este deber, a este estándar sobre el deber de proteger de manera igualitaria y simultánea a dos personas que sufren una condición de salud.
Yeah.
En un caso posiblemente fatal y en el otro caso donde se sabe que una vez que esa dependencia física se corta, va a concluir con un desenlace fatal. Que la ciencia ya nos dice.
Right.
Me pareció escuchar de los peritajes y los testigos anteriores que eso no estaba en disputa. Eso nunca fue un hecho en disputa en este caso. Entonces, ¿cómo tenemos que utilizar la ciencia? Porque a final de cuentas, esa protección simultánea e igualitaria, en algún momento debemos llevarla al terreno de lo concreto, ¿no? En los casos particulares.
Right. I think I understand the question better now. Thank you. And perhaps it might be useful to put it this way. Science, as I said, has to inform the judgment about what is needed medically, what the likely effects of an intervention are, what the comparative implications of particular interventions would be on the mother and the child. So when I say equally and simultaneously, it doesn't mean doing the same things to both, right? Medical treatment has to take into account who the patient is in both cases. And so in all these ways, medical science informs the judgment. But it's also important to remember what medical science can't do, right? It is not science that tells us that a human life is valuable. Science has nothing to say about the value of a human life. And so it's not science that can tell us that a child that is not viable beyond a few hours outside the womb has no value or no dignity. That's not a scientific statement at all, and it can't be. It's categorically outside the realm of science to make that affirmation.
Muchas gracias por su respuesta. Esa era mi pregunta, señor presidente.
Muchas gracias. Señora jueza Nancy Hernández López, ¿va a realizar preguntas?
Sí, señor presidente.
Adelante.
Muchas gracias. Profesor, buenas tardes. Yo entiendo de su disertación que usted no se opone a que se haga un juicio de ponderación de vida versus vida cuando no hay otro remedio para salvar una de esas dos vidas cuando entran en colisión esos intereses.
Yes, but let me add a little bit of an explanation to it, only because of the word ponderación, I think has to be weighed carefully. Yes, it's certainly true that in order to save the life of a pregnant woman, where it's clear that is the medically appropriate intervention, sometimes immediately without even further analysis or judgment because it's an emergency. Let's say, for example, again, the medicine is a little bit beyond me, but even the little things that I know, let's say it's an ectopic pregnancy, right? I think we all know that those pregnancies need to be terminated as quickly as possible in order to save the life of the mother. I think that's entirely appropriate and consistent with the duties of the state to protect life in these cases. Yes.
Gracias. Retomando una pregunta que le hicieron los representantes, mismo caso, pero para tutelar el derecho a la salud de la madre. Me imagino, yo tampoco soy médica, pero un caso donde la madre tiene cáncer, necesita llevar su quimioterapia, si no la lleva se muere, pero la quimioterapia mata su embarazo, digamos, su embrión.
Yes.
No habría otro remedio más que tutelar la salud de la madre, porque si no se mueren los dos.
Well, but there it already gets a little bit more complicated than, for example, in the ectopic pregnancy, right? Because let's say, for example, the tumor that needs to be treated has been discovered at a time period in the gestational time where it would be possible to actually prematurely deliver the baby alive. Then there is an affirmative obligation to attend to the health and life of the child as well, right? Or there might be more than one. I myself am a cancer survivor. I was given many options to my chemotherapy, and some were more severe than others. Informed consent of the woman might involve questions about saying, this is a form that would definitely kill the child in your womb. This is one that might not, but it also might be less effective. How are we going to make that judgment? So as the cases get more complex, there will be ways, certainly, in which the state can reasonably, not the state, I'm sorry, the pregnant woman and the medical care provided by the state, so indirectly the state, can take steps to protect the life and health of the unborn child as well, even in these severe cases where the life of the mother is at stake.
Sí, pero si no se puede, también
and of course, if it's
vale el juicio de ponderación igual. O sea, ahí va a depender de los elementos del caso concreto. Volvemos al tema
yes,
de vida versus vida,
yes,
salud versus vida, con juicio de ponderación.
Yes, and again, let me, because I didn't clarify before, I think the word weighting, ponderación, balancing is an uneasy one, right? Because it is not weighing the value of one or the other or the rights of one another so much as saying what we're trying to do is save one to the extent it's possible. We will save the other or protect the health of the other, but where that is an indirect consequence of the intervention, then it is acceptable as a juridical matter and as an ethical matter, I believe.
Muchas gracias. No tengo más preguntas.
Juez Humberto Sierra Porto, ¿va a realizar preguntas?
No, señor presidente, agradeciéndole al perito y al perito de la comisión que han tenido sus puntos de argumentación muy claros.
Muchas gracias. Señor juez Eduardo Ferrer MacGregor, ¿va a realizar preguntas?
No, señor presidente.
Bien, este tribunal agradece su presentación. No tenemos más preguntas.